Hello and welcome to Moneylife. This is Sucheta Dilal. This week, I'm going to discuss SEBI's Code of Conflict again. And even as I'm completing this video blog for the second week in a row, the Congress Party has once again made some bombshell allegations against the SEBI chairperson, Madhvi Puri Buch. In fact, when asked to explain these charges by the Parliamentary Accounts Committee, Madhvi Puri Buch skipped the meeting on 24th October. Before that, on 30th September, the board of directors of SEBI met and acted as though there was no issue at all and carried on like it was business as usual without addressing this large elephant in the room. So what happens? Does anyone discuss it? After that, I discovered that this code of conflict or code of avoidance of conflict of interest, which the SEBI board members voluntarily decided to adhere to in December 2008, is itself completely illegal. Now, was Ms. Buch and other whole-time members, remember, this time Congress has made allegations against another whole-time member who has used the revolving door to come from the private sector into a regulatory capacity, Anant Narayanji. And the charges are pretty serious because they're talking about connections with regulated entities. My question is, who's going to investigate all this? There is a flimsy code to avoid conflict of interest, which I'm now going to call the conflict code. I have done a whole video blog on this just last week. I've written a column in Moneylife. And now there are new allegations that is lying unaddressed. At stake here is not about politics. It's not even about Madhvi Puri Buch, though to an extent it is. At stake here is not about political gamesmanship. It is about the integrity of India's regulatory framework. Since SEBI oversees one of the largest capital markets in the world, one of the top 5, with a market capitalization of $5 trillion and 10 crore investors, few lakh intermediaries, people coming in through mutual funds, all these are regulated day in and day out by the Securities and Exchange Board of India. There are 4 officials at the top, the chairperson and 3 whole-time directors, and of course members of Ministry for Corporate Affairs and the Finance Ministry. Together, they are making rules, deciding punishments, barring people, stopping businesses. What are the rules that apply to them? And they cook up a code of conflict and say, oh, fine, we adhere to it. Nobody needs to know because we will not answer any questions. We will not appear before a parliamentary committee. The Finance Ministry, for some strange reason, will not ask questions. And a legally void code continues. In fact, let me reiterate, the illegality of the conflict code is crystal clear. The government's power to frame service rules emanate from Section 5(1) of the SEBI Act 1992, amended several times. Section 29, read with Section 2F, requires that these rules, this is the important part, the government alone can make rules. They need to be published in the Union Gazette to have any standing. And Section 31 further mandates that rules so framed shall be placed before Parliament for approval. None of this has happened. In fact, the SEBI chairperson doesn't turn up before a joint parliamentary committee. First, now let's look at the terms and conditions. There are some terms which, according to top lawyers and those associated with the capital market, are important. Section 19A1, terms and conditions of service of the chairperson and members, framed in 1992, when actually there were no whole-time directors, so amended in 2018. It says the chairman of WTM shall be a person who does not and will not have any financial interest, financial or other interest, as are likely to affect prejudicially his functions as such chairman or member, which means there's no scope to voluntarily adopt a diluted conflict code as was done in 2008. Because you just cannot have conflict. You cannot say, I'll trade, I'll disclose, I'll recuse. All this says you cannot have conflict of interest in the first place. Section 19, main section, explicitly says that service matters with respect to which no express provision has been made in these rules shall be referred in each case to the central government for its decision, and the decision of the central government shall be final. This conflict code of 2008 never seems to have gone to the central government, has not been approved, has not gone to parliament, has not been published in the Gazette. Now, Section 20 says the central government shall have the powers to relax the provisions of these rules with respect to any class or category of persons. No such relaxation or dilution of the service rules has been permitted by the central government. Perhaps aware that this whole thing is so dodgy, the SEBI board in December 2008 decided that, and this is the wording, this code shall be in addition to provisions of Section 7A of the SEBI Act 1992, Rules 313 into bracket 1, 19A1 of the SEBI, all the things that I've said above, right? Which means that they know, and it will be in addition to. So what does in addition mean? In addition means that rules framed by the government stand, they are primary, they are published, they are legally valid, and will be adhered to. Anything else you do can be over and above this, can't dilute it. But SEBI's conflict code has diluted it. So the code is meaningless. You cannot say that stricter government rules are below this loose conflict code. So all we are hearing is we complied with the conflict code. That's the bare minimum. Nobody knows which code, which recusals, what was disclosed, because nobody is talking. The board won't ask. SEBI is not saying anything. As Advocate Murli Neelkantan told me last week, and I'm repeating, the code is void for lacking legislative competence. Now, 16 years, remember 2008 to 2024. Is it that it was just lying mothballed and nobody had a clue? No, it was amended in 2018. So the rules were amended. It was not completely mothballed. There were no WTMs in 1992 when the first rules were framed. Then when these service conditions were revisited, was that in 2018, did nobody say, hello, this code of conflict has to be taken to the government, has to be published, we have to get its approval, take it to parliament? It's lying there. There were no private sector entrants at that time, but 2018 is after Madhvi Puri Butch came in. She came in as a whole-time member in 2017. So did the chairperson, Mr. Tyagi at that time, when it was being amended, did not realize that here is a private sector person who's come in for the first time, and this conflict code is, as it is, so weak and invalid. Should we now go to the government? What happened in 2018? Nobody knows, because SEBI stonewalls. The question is, who will investigate the issue and initiate corrective action? SEBI has not one but two private entrants now. There are serious allegations by the Congress party today against both of them, and neither SEBI showing any interest or indication of wanting to address, investigate, or correct the situation. Central government is more focused on defending them and dismissing the matter as a political slugfest. And this avoidance means that the illegal conflict code remains in place, exposing the regulator to further credibility erosion. But credibility erosion is one part. Just think about the unfairness of it. Every market intermediary is subject to such mind-bogglingly stringent rules. Some of them have closed their business because the cost of compliance is not worth the effort. But SEBI's top brass, with extraordinary and immense powers to make rules, emergency powers that allow it to ban people from the market, halt their business overnight, are themselves subject to very weak and opaque rules. I said last time, it only applies to spouse and to minor children below 18 who are not dependent. And they're allowed to trade all kinds of things that are not allowed by any regulator worth their salt anywhere in the world. And we take pride in being part of this International Association of Securities Commissions, and we are not embarrassed at an illegal conflict code. Maybe it's time even bodies like IOSCO begin to ask questions and tell SEBI, are you compliant? In fact, the laxity in SEBI standards is a larger issue. It extends beyond the conflict code because there's a worrying lack of transparency about a lot of SEBI's functioning. For instance, one big example that's being fought out in court today is the secret exemption from reverse book building that was granted to ICICI Securities, which merged with ICICI Bank a few months ago. Now, investors of ICICI Securities feel that they've got a raw deal, the valuation was low, they've gone to court. The basis on which the exemption was granted is not known. They're even fighting in court to say this should be out in the open. And SEBI is strongly defending its stand that it will be secret. And what is the reason is not known. In fact, SEBI in a latest affidavit has argued in court that the exemption is an administrative decision that does not contemplate a hearing and the passing of a reasoned order. So it does not need to pass a reasoned order, even though this is an exemption for a large bank, even though it impacts so many shareholders of ICICI Securities who feel that their valuation was low. More importantly, Ms. Puch was directly associated as the head of ICICI Securities and has been regularly encashing employee stock options from ICICI Bank over the 10-year period and the 7 odd years that she's been in SEBI. In fact, this is the first controversy that broke out about conflict of interest. With no support from the regulator, these investors are in court, having to go to a civil court, which is less familiar with the nuances of capital market regulation. SEBI has also aggressively defended its secrecy on another grounds. In a recent affidavit, SEBI argues that the Supreme Court, in a catena of judgments, has emphasized the need for giving wide latitude of judicial deference to decisions taken by expert regulatory bodies in the realm of finance or economics. So they don't have to be reasoned, they can be secret, and there should be a wide latitude. So it's telling the High Court that you should not use your writ jurisdiction to interfere with a SEBI decision. How extraordinary. Similarly, SEBI has the power to waive disclosures for companies planning to list through an initial public offering. There's no transparency on the process. In fact, SEBI insiders tell me, depending on who the merchant banker is, these waivers are given. Nobody knows who gets them, who doesn't. Investors certainly don't know. It is the same with the issue of settlement of offenses. So you pay a fat amount. Some call it a fee, but it's just a payment of a sum of money without admitting or denying guilt. The process is non-transparent, and the amounts paid, they say, depends on the officer's skill, the officer in charge, and the skill of the negotiating lawyer, not on the seriousness of the offense. Another big problem is SEBI's legally weak and contradictory orders. This has led to repeated strictures by appellate tribunals and courts. Many whole-time members have no legal background, so important cases have just crumbled on appeal because they have throwaway sentences that seem to exonerate the main accused. And this may be deliberate or otherwise, but it destroys months and months of investigation. One example of this is the National Stock Exchange co-location scam, which I broke in 2015. After dragging on for almost a decade, 9 years, the National Stock Exchange is now wanting to just pay money and settle all these issues, even though it has scored major victories and reprieves in appeal. But it's like 9 years, NSE is saying enough is enough. It wants to list, so it wants to pay, and it has already made a big payment. So here's the sum total of what you have. On one hand, latitude from courts because of the catena of judgments which have said do this because this regulator is an expert and understands the domain. Doesn't matter that its whole-time members may not have much domain knowledge and have flown in from outside. So latitude from courts combined with lack of effective oversight by the finance ministry and the central government leads to a dangerous level of freedom and lack of accountability for the SEBI chairperson and WTMs. It has been going on for a long time. There are no questions asked. They make the rules. They make the decisions. It is an immensely powerful body. Since the government seems determined to stonewall any discussion on SEBI and its functioning, the real question is, who will hold SEBI accountable and protect investors? Any answers? If you do, write in to us and share this video. Thank you.